everyone, a very good afternoon all of you. Please join in. कैसे हैं आप सब? क्या हाल है सबके? Good afternoon everyone. Let's start with the session. Alright, so what we are going to talk about today is, am I audible? Am I audible to everyone? Good afternoon, Dushita. Alright. See, so today's topic that we are going to discuss here is about witness, right? So basically जब हम इंडियन एविडेंस एक्ट की बात करते हैं, so you know who is a witness? Alright, the first question is कि भाई आप एविडेंस की जो बात करते हो या who can be a witness? So that evidence is presented, you know, by a witness or generally ऐसे भी in the court. Alright, so if it is a oral evidence, then it has to be a witness. Now the thing is that, you know, who is this witness or who can be a witness? That is a question that we need to ask. ठीक है? Who can be a witness? So when you read chapter 9, जब आप chapter 9 पढ़ते हैं of Indian Evidence Act का, ठीक है? Indian Evidence Act 1872, chapter 9. So that chapter 9 is related to what? जब आप देखेंगे अपने बेयर एक्ट में तो वहाँ क्या लिखा हुआ है? chapter 9 of witnesses. ठीक है? ये लिखा हुआ है वहाँ पे. Fine. है कि नहीं? Are you sitting with your bear acts, everyone? बताइए, यहाँ तक क्लियर है? जब भी आप बेयर एक्ट पढ़ते हैं तो वहाँ पे क्या दिया होता है? वहाँ पे चैप्टर नंबर दिया होता है और वहाँ पे चैप्टर 9 के चैप्टर नंबर के नीचे लिखा होता है चैप्टर ऑफ व्हाट. सो दैट इज चैप्टर 9 इज चैप्टर ऑफ विटनेसेस. ऐसे करके ही मेंशन्ड है ना, चैप्टर ऑफ व्हाट. सो दिस इज अ चैप्टर ऑफ विटनेसेस. ये तरीका है बेयर एक्ट पढ़ने का. ठीक है, अब यहाँ पे जब आप सबसे पहला क्वेश्चन देखते हैं तो जनरली जो है आपका 118 से लेकर पर्टिकुलरली 118, वैसे तो और भी सेक्शंस हैं, 118 से लेकर 121 तक. एंड उसके बाद एक और सेक्शन आता है आपका सेक्शन 133 जो कि अकम्प्लिस का सेक्शन है, जो हम अलग से करेंगे. ऑलराइट, बट यहाँ मैं लिख रही हूँ. सो 118 से लेके 121 तक ये जो सेक्शंस हैं आपके, ये आपको बताते हैं किस चीज़ के बारे में? दे टेल यू अबाउट द कॉम्पिटेंसी ऑफ विटनेस, कि विच पर्सन और हु इज़ दैट पर्सन हु विल बी कॉम्पिटेंट एज अ विटनेस. सो कॉम्पिटेंसी ऑफ विटनेस, कॉम्पिटेंसी ऑफ विटनेस, ये बात करते हैं. सो 118 से लेके 121 कॉम्पिटेंसी बताता है कि ये लोग जो हैं वो कॉम्पिटेंट हैं. तो ये कैटेगराइजेशन थोड़ा आपको ध्यान रखना है. ठीक है, एंड इसके बाद, अच्छा ये मैंने इरेज नहीं किया था कल वाला, चलो मैं ये लिखने के बाद इरेज कर दूंगी. इसके बाद जो है आपको ये ध्यान रखना है 100 सेकेंड. तो ये तो हो गया 118 से लेके 121 तक कॉम्पिटेंसी ऑफ विटनेस. अगर मैं इसको इधर शिफ्ट करूं, अगर आपको ये याद है रहे तो, सो बेसिकली सेक्शन 122 से, ऑलराइट, 122 से 129 तक देयर इज अ सिचुएशन जहाँ पे, लिसन टू मी वेरी केयरफुली, ऑलराइट, 122 से 129 तक देयर इज अ सिचुएशन जहाँ पे अगर विटनेस कोई एविडेंस देना भी चाहे या कोई टेस्टिमनी देना भी चाहिए, if the witness, wants to disclose, or if somebody else wants the witness to disclose the testimony. So it cannot be done. The witness cannot be compelled, or even if the witness wants to, so the witness cannot be permitted, all right, to give such an evidence, all right, or to give such a testimony. इसीलिए यहाँ पे जो communications होती हैं उसको हम क्या कहते हैं? We call them privileged communication, all right, we call them privileged communication. Is it clear everyone? Bifurcation is clear? समझ में आ रहा है? समझ में आ रहा है या नहीं समझ में आ रहा है? बताइए जल्दी. Bifurcation is clear? So 118 to 121, basically it is talking about the competency, right? And 133 is also, which tells you that whether an accomplice can be a competent witness or not. It is written, when you read section 133, it is written over there that whether accomplice can be a competent witness or not. और उसके साथ फिर आप 114B का illustration पढ़ते हो, ठीक है, accomplice के साथ. That is a separate topic, leave it. But वो competency में ही आता है. This is from your mains perspective, अगर आपको ऐसे लिखना हो तो witness के बारे में. And आपके दिमाग में भी ये bifurcation होना चाहिए. इसके अलावा जब हम privileged communication की बात करते हैं कि अगर witness, हमें पता चल गया कि ये witness है, ये इंसान competent है, he can be a competent witness, but still the person is prohibited, still the person is, cannot be, even if not prohibited, still the person cannot be compelled to give a particular testimony. Why? Because the communication about which he is about to give the testimony, जिस communication के लिए वो testimony देना चाहते हैं, that particular witness, that falls under the category of privileged communication. It is not just any communication, it is a privileged communication. So that is how you need to understand it. Now, today's focus is mainly about competency, that who may testify. So we will focus from 118 to 121. Now let's understand this. What is it? 118 to 121. Okay, I'll erase this so that the entire board get clear. Right. Now let's see what does section 118 has to say. So see, basically witnesses का significance क्यों है इतना ज़्यादा? Because witnesses are considered to be the, Bentham का statement है that witnesses are considered to be the eyes and ears of justice. All right, witnesses are considered to be the eyes and ears of justice. अगर witnesses ही नहीं होंगे, ठीक है, so वो trial जो है वो effectively possible नहीं हो पाएगा. So you need witnesses, and there are several factors which can lead to, incompetency or incapacitation of witness. कई सारे factors की वजह से ऐसा हो सकता है कि witnesses जो हैं वो सही तरीके से evidences या testimony नहीं दे पाएं, ठीक है. Not just about competency, बहुत सारे factors, external factors होते हैं, ठीक. अब let's see what does 118 say. So 18 answers the question who may testify. कौन testify कर सकता है, मतलब कौन competent है testify करने के लिए. So it says all persons shall be competent to testify. तो कोई रोक ही नहीं है, all persons are competent to testify basically. So shall भी लिखा है, all persons shall be competent to testify, ठीक. Shall be competent. Fine. So all persons shall be competent, okay, unless, now there is a condition attached to it, कि भाई कोई भी testify करे, but वही इंसान testify कर सकता है जो कि questions, whatever the questions are put to the person by the court, and the person is able to understand that question. अब कोर्ट ने कोई सवाल पूछा, अगर सामने वाला वो सवाल नहीं समझ पा रहा कि उसका जवाब क्या होगा, ठीक है, या फिर रैशनल आंसर क्या होगा, सो देन इन दैट पर्टिकुलर केस आप नहीं कह सकते कि वो जो है अ कॉम्पिटेंट विटनेस है. और वो क्यों नहीं जवाब दे पाएगा, क्यों रैशनल आंसर नहीं दे पाएगा, क्यों नहीं समझ पाएगा, उसके भी फैक्टर्स दिए हुए हैं. बिकॉज ईदर ही इज़ ऑफ यंग एज, or he is of extremely old age, or the person is suffering with some disease, whether that disease is of body or mind, or any other cause of the same kind or any other cause of the same kind. All right, so what does that mean? I'll read the section before you. All persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to those questions, and by tender years, extreme old age, disease, whether of body or mind, or any other cause of the same kind. Now, I'm not going to write it like the way it is written in the section. I'll just write unless, I'll here write unless due to, I'm breaking the section, due to tender years, and you can write down with me, due to tender years, ठीक है, or due to extreme old age, tender years means a child, right, young age, extreme old age, or due to any disease of body or mind, ठीक है, और एनी अदर कॉज ऑफ द सेम काइंड, मतलब इन्हीं से रिलेटेड, यू नो, इजस्डम जेनरस रूल जैसे हम कहते हैं, ठीक है, एनी अदर कॉज ऑफ द सेम काइंड, एनी अदर कॉज, इन कारणों की वजह से, ठीक है, द कोर्ट कंसिडर्स, इन कारणों की वजह से, ऑलराइट, द कोर्ट कंसिडर्स, जस्ट अ सेकेंड, cause the court considers what? That they are prevented from understanding the questions put to them or from giving rational answers to those questions. The court considers कि they won't understand the question put to them. They won't understand the question put to them. ठीक है, और अगर ये क्वेश्चन मान लो समझ भी गए, ठीक है, अगर ये क्वेश्चन समझ भी गए, सो दे कांट गिव द रैशनल आंसर्स, ठीक है, और कांट गिव रैशनल आंसर्स. ठीक, सो दैट इज व्हाट इट इज सेइंग कि 118 में व्हाट दे आर सेइंग इज that any person can testify. Can you see this now, everyone? I think everyone can see this. Any person, all person, you know, shall be competent. All person should be competent, except, you know, unless because of these mentioned reasons over here, the court को ऐसा लगता है, the court considers that they won't understand the questions which are put to them or they won't be able to give the rational answers related to this. Clear? Is it clear, everyone? तो आगे चलें. आगे चले. देन देर इज एन एक्सप्लेनेशन जो कि आपका प्रिलिमिनरी का बड़ा ही फेवरेट क्वेश्चन है. दे आस्क दैट वेदर अ लुनाटिक इज अ कॉम्पिटेंट विटनेस. यस, अ लुनाटिक इज अ कॉम्पिटेंट विटनेस unless the lunatic is not able to understand the question, all right, or provide a rational answer to it because of the lunacy. So जो lunatic है वो competent witness है unless the lunatic is not able to understand the question or provide the rational answer related to it. So is lunatic a competent witness? Yes. So explanation जो है आपके further all persons को ही, ऑल पर्सनस को और डिजीज ऑफ बॉडी और माइंड को ही बेसिकली जो है वो हाईलाइट करता है, फर्दर इलाबोरेट करता है. तो वो कहता है कि भाई लुनाटिक जो है वो भी कॉम्पिटेंट है अनलेस बिकॉज ऑफ द फैक्टर डिस्कस्ड अबव. ठीक है, सॉरी, कॉम्पिटेंट है unless because of the factor discussed above he is not able to you know talk about or understand the questions or give the rational answer related to it. ठीक है, क्लियर? बताइए, तो फिर आगे चलते हैं. देन वी मूव टू सेक्शन 119. Alright, let's move to 119. Quickly. Now what is 119? What is 119? So 119 says witness unable to communicate verbally. Now पहले यहाँ पे dumb witness लिखा हुआ था, but then there has been an amendment, alright, in the year 2013. Fine. So if a witness is unable to communicate verbally, and there can be so many reasons. The person might be hospitalized, and because of the injuries the person might not be able to speak, or the person might be in a state of shock, all right, or the person is incapacitated to speak. So there can be so many reasons. बहुत सारे कारणों से हो सकता है कि the person is not able to communicate verbally. इसका मतलब हमेशा ये नहीं हो सकता कि वो पहले से ही नहीं बोल रहा है, ठीक है, ये पहले से ही कुछ स्पीकिंग इम्पेयर्डनेस है या फिर लिसनिंग इम्पेयर्डनेस है. So that is why now this has actually made the section much wider, this amendment. All right. So because of any reason, if the person is not able to communicate verbally, so then what will happen? It will always depend upon the facts and circumstances of the case. You're talking in terms of lunatic, Tushita? Are you talking in terms of lunatic? See, try and understand. Competency of a witness and admissibility of an evidence. These are two different things. We are at the first stage in the sense, now whether that evidence or testimony, fine, इसको समझो, इस बात को समझो कि competency of the witness and admissibility of the evidence are two different things. Admissibility of the evidence is for the court to decide. The court decides under section 136 of your Indian Evidence Act. Now that is an altogether different discussion. अभी तो हम बस ये डिसाइड कर रहे हैं ना कि भाई विटनेस कौन हो सकता है. उस विटनेस की टेस्टिमनी या आप जो डॉक्यूमेंट प्रोड्यूस कर रहे हैं उसकी वैलिडिटी वो एज एन एविडेंस एक्सेप्टेबल होगा कि नहीं होगा कोर्ट में, दैट इज टू बी सीन एंड दैट इज ऑलवेज फॉर द कोर्ट एट द एंड टू डिसाइड. अभी तो बस हम ये डिसाइड करते, इट्स जस्ट लाइक अभी हम ये डिसाइड करें कि वेदर आप कॉम्पिटेंट हो कि नहीं हो एग्जाम में बैठने के लिए. ऑलराइट, फाइनली क्या होगा, ठीक है, दैट हैज टू बी डिसाइडेड बाय अदर अथॉरिटीज. यू गेट माई पॉइंट? Is it clear? ठीक है, आगे चले. ठीक है. So section 119 क्या कह रहा है कि if a witness is unable to speak, if a witness is unable to speak, then in that a witness who is unable to speak, all right, let's write it down, unable to speak, then he may give his evidence in any other manner in which he can make it intelligible. अगर वो बोल नहीं सकते, so what can he do? He can give the evidence in any other manner in which he wants. Alright, and which makes the evidence understandable. Intelligible मतलब understandable. तो sign language से या लिख के या indicate करके कैसे भी. So a witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible, as by writing or by signs. लिखा है ना? Unable to speak, so how can he give evidence? Either by writing or by signs. ठीक, but such writing must be written and the signs made in open court. Evidence so given shall be deemed to be oral evidence. आपसे जो एग्जाम में पूछते हैं वो ये पूछते हैं कि what is the nature of the evidence. So this evidence is considered to be a oral evidence. ये जो evidence है यहाँ वाला, ठीक है, it is considered to be a ओरल एविडेंस. ओरल एविडेंस कहाँ दिया है? सेक्शन 59 इफ़ आई एम नॉट रॉन्ग. एक बार चेक कर लीजिएगा. डू चेक सेक्शन 59 ऑफ योर इंडियन एविडेंस एक्ट. ऑलराइट, ठीक. सो दिस इज कंसिडर्ड टू बी अ oral evidence, provided that if the witness is unable to communicate verbally, the court shall take the assistance of an interpreter or special educator in recording the statement, and such statement shall be videographed. It's a common sense thing, right? If a person is not 59 only, right? So if the person is not able to speak, so obviously you have to, or if the person is speaking in some other language, let's suppose, if the person is using a sign language, so definitely you need an interpreter or a special educator to make the things intelligible. Because what is the condition? That if you are unable to speak, you can present the witness the way you want to, evidence the way you want to, like in writing or in signs, but it should be intelligible. So that is the purpose of the interpreter and the special educator, to make the evidence intelligible. All right. सो इसलिए उनका होना ज़रूरी है. और फिर उसके बाद और क्या ज़रूरी है कि भाई आप उसको वीडियोग्राफ भी करें, ताकि कल को जब आप इसको कोर्ट में प्रेजेंट करें तो कोई डिस्क्रिपेंसी ना हो. राइट, एज एन एविडेंस जब आप इसे करें तो कोई, वैसे तो कोर्ट में ही होना है ये, पर कोई फिर भी कोई डिस्क्रिपेंसी ना हो आपके इंटरप्रिटेशन में और जो सामने वाले ने कहा उसमें. मतलब जो बताया उसमें, चाहे लिख के चाहे साइन लैंग्वेज से. So that is what section 119 is saying. Now what is section 120? 120 is very simple. It's simply saying that जो parties to civil suit होते हैं, ठीक है, when you read section 120, सिंपल सी बात है भाई, तो उनके हस्बैंड और वाइफ भी तो कॉम्पिटेंट विटनेसेस होंगे. अब चाहे फॉर हो चाहे अगेंस्ट हो. कुछ सिचुएशंस में अगेंस्ट नहीं हो सकते, उनका कम्युनिकेशन वही हमारा प्रिविलेज कम्युनिकेशन है. सो वो क्या कह रहे हैं कि जो पार्टीज टू सिविल सूट हैं, प्लेंटिफ और डिफेंडेंट, and their wives or husband, also husband or wife of the person under criminal trial, that is the accused, right? Fine. So also what you have to understand is this a class for CLAT PG? Okay, now listen to me. So when you are talking about parties to civil suit and their wives or husband, जहाँ भी evidence law आता है आपको काम आ जाएगा, don't worry. So when you are talking about parties to civil suit and their wives or husband, like plaintiff and defendant, या फिर उनके wives or husbands, या फिर the person who is under trial, so an accused basically. So the accused का wife or husband, so there can be a female accused as well, all right. So accused का wife or husband, they are competent witness. They are competent witness. आपको ये ध्यान रखना है. So I'll just read. In all civil proceedings, the parties to the suit and the husband or wife of any party to the suit shall be competent witness. ठीक है? Shall be competent witness. Right? In any criminal proceedings against any person. Now, if the criminal proceeding is against any person, the husband or wife of such person respectively shall be a competent witness. Now, try and understand that witness ka testimony can go in the favor also, can go in against also. What they are just saying in the section is, what is the requirement of the section is that they are competent witness. आपको इतना ध्यान रखना है बस, ठीक है? They are competent witness. Clear? आगे चले. The last section for today. Section 121. So 121 is basically talking about judges and magistrates. कि judges and magistrates भी competent witness हो सकते हैं क्या? Because the matter is going on in their court. So can the judges and magistrate be a competent witness? Alright. So it says that no judge or magistrate shall, except upon the special order of some court to which he is subordinate, be compelled to answer any question as to his own conduct in court as such judge or magistrate. कहने का मतलब सिंपल सा है, आप जज और मैजिस्ट्रेट के कोर्ट में हो, ठीक है, जज मैजिस्ट्रेट, ठीक है, you are in the court of this judge and magistrate, the proceeding is going on. Now this judge or magistrate, they cannot be compelled, ठीक है, cannot be compelled to answer questions with respect to the capacity in which they have worked. Are you understanding? कि ये जज और मैजिस्ट्रेट होते हुए उस केस को हैंडल करते वक्त, ट्राई करते वक्त, ऑलराइट, ये जज और मैजिस्ट्रेट होते हुए उस केस को हैंडल करते वक्त, ट्राई करते वक्त उन्होंने जो भी काम किया है उस काम से रिलेटेड कोई क्वेश्चन उन्हें नहीं किया जा सकता. दे कैन नॉट बी कंपेल्ड टू आंसर द क्वेश्चंस रिलेटेड टू दैट unless and until, all right, unless and until, you know, there is some special order from the authority to whom they are subordinate. That is what the section is saying, that no judge or magistrate shall, except upon the special order of some court to which he is subordinate, be compelled to answer any question as to his own conduct in court as such judge or magistrate. So the, you know, the cases which they are trying or handling, or you know, with respect to any such judicial proceeding that is going on, so as a judge or magistrate they cannot be compelled to answer that question unless and until there is a special order from the authority to whom they are subordinate. But having said that, if you know they have witnessed something else, in meaning thereby, what is it's written over here? Be compelled to answer any question as to his own conduct, ठीक है, or as to anything which came to his knowledge in court as such judge or magistrate, या फिर you know with something which comes to his knowledge while working as that judge or magistrate of that court. But he may be examined as to other matters which occurred in his presence while he was so acting. But he can be examined for other matters. For example, you know, a judge trial is going on. So Delhi में तो इतना सारा कोर्ट में जो है वो blast and all हो रहा है. So while the trial is going on, all right, and suddenly, you know, there is some blast, some noise outside, or some incident happened which is not related to that trial, but something while he was working as that judge or magistrate. So definitely he can be examined for that particular incident. Are you getting the incident? कि अचानक जब आप ट्रायल कर रहे हैं एज अ जज और मैजिस्ट्रेट, तो कोई ऐसी घटना हुई जब आप ट्रायल कर रहे थे तो उसी प्रेमाइसेस में आपको पता चला, तो उस चीज़ के बारे में एग्जामिन किया जा सकता है विदाउट इवन द स्पेशल ऑर्डर. Without even the special order, then you become a competent witness. Is it clear? Let's read the illustrations, फिर और ज़्यादा clear होगा. Clear है? क्या आगे चले? So what is it saying? Illustration क्या कह रहा है? So A जो है, let's understand this illustration. ए जो है क्या कर रहा है? ए है ऑन हिज ट्रायल. ऑलराइट, ए इज ऑन हिज ट्रायल. किसके पहले? बिफोर द कोर्ट ऑफ सेशन. कोर्ट ऑफ सेशन के सामने ए का ट्रायल चल रहा है. ठीक है. सेज दैट अ डिपोजिशन वॉज इम्प्रॉपरली टेकन बाय बी द मैजिस्ट्रेट. अब ए का ये एलिगेशन है कोर्ट ऑफ सेशन के सामने कि बी ने, जो कि मैजिस्ट्रेट था, ठीक है, बी मैजिस्ट्रेट, so the magistrate has taken the deposition not so properly. जो deposition लिया testimony का या evidence का, that was not so proper. It was not done properly by the magistrate. And किसके सामने ये कह रहे हैं? ये court of session के सामने कह रहे हैं. ठीक है. So I repeat, A on his trial before the court of session says that the deposition was improperly taken by B, the magistrate. B cannot be compelled to, अब B को आप बुला के compel नहीं कर सकते आंसर करने के लिए questions as to this, except upon the special order of a superior court. Unless and until there is a superior court. अब ये नहीं बोल सकता कि okay, B is my witness. You understand that magistrate is going to be my witness, I'll call him. No, unless and until there is a superior court का order, ठीक है, you cannot call B and examine him as a witness. You cannot call B and examine him as a witness. Just a second. ठीक है? ठीक. But if let's suppose A is accused before the court of session of having given false evidence before B, a magistrate. Sorry, let's come to illustration C. Let's come to illustration C. A is accused before the court of session of attempting to murder a police officer. और court of session के सामने trial चल रहा है. A is accused for what? For murdering police officer. Murder का trial चल रहा है. किसको मर्डर किया है भाई? पुलिस ऑफिसर को मर्डर किया है. ठीक है. सो ए इज accused before the court of session of attempting, basically attempt to murder का है. Attempt to murder. Alright. So A is accused before the court of session of attempting to murder a police officer while on his trial before B. A session judge. B may be examined as to what occurred. So जब वो ट्रायल चल रहा था, ठीक है, ए का ऑलरेडी ट्रायल चल रहा था, तो इस ट्रायल के वक्त जो है ही ट्राइड टू मर्डर द पुलिस ऑफिसर. दैट इज द फैक्ट. एक्चुअली ए का ऑलरेडी ट्रायल चल रहा था और इस ट्रायल के वक्त जो है ही अटेम्प्टेड टू मर्डर द पुलिस ऑफिसर. सो ये जो घटना हुई, ये वाली अटेम्प्ट टू मर्डर वाली, ठीक है, इस ट्रायल के वक्त, सो फॉर दिस द judge can be examined. For this, the judge can be examined. Is it clear? Is it clear, everyone? बताइए. क्लियर है? ठीक है. All right. Then that is all for today, regarding the competency of the witness. As I told you कि privilege communication वाला part अलग है, where the witness cannot be compelled. All right, 122 to 129. ठीक? So that is altogether a different discussion. So we'll meet with another topic. So thank you so much for joining in. If you are new to the channel, please subscribe to it and like it and share it. And again, we'll be meeting with a fresh topic. All right? Yes. But only दो bifurcations हैं, Riddhi. There are two bifurcations. All right? Related to the trial, which he himself is, going through in the sense which he himself is conducting. So there, just a second. So related to the trial which he himself is conducting, so there, in that particular case, he can only be examined when there is an order from the superior court. But something else happens which he has witnessed while, going through that trial. As I gave you the example of bomb blast. All right, a bomb explosion. Or something like that, or attempt to murder a police officer. So for that he can be examined. So there is a bifurcation. बस वो bifurcation याद रखना. Right? So thank you so much all of you. God bless. Take care. Bye-bye. And we will be joining in again. If you have any question, please send it to the comment section and I'll take care of it.